4 is the court pillar. To this group belongs the municipal trial courts for crimes punishable by imprisonment not exceeding 6 years, the Sharia Circuit Courts, and the ARMM for criminal violations of Muslim Code. The regional trial courts for crimes punishable by imprisonment of more than 6 years and appeals from the decision of the municipal trial courts. The Sandigang Bayan for crimes committed by government officials with salary grade 27 and above, regardless of the penalty prescribed for the offenses charged, and appeals from the decisions of the regional trial court in criminal case against government employees below salary grade 27. The Court of appeals from the decisions of the regional trial courts in criminal cases against non-government people, and the Supreme Court for appeals from the decisions of the Court of Appeals, Sandigang Bayan, and atomic reviews of decisions of the regional trial court and the Sandigang Bayan, where the penalty imposed reclusion perpetua or death. So the municipal trial court is for the crime punishable by imprisonment not exceeding 6 years. The Sharia Circuit Court in the ARMM for criminal violations of Muslim Code. So the court pillar where the case will be moved here if prosecution determine a probable cause. This court pillar is truly independent, just and speedy to the end of the innocent person is convicted and no guilty man is acquitted. There is also a chance that these criminals will reverted return to the community if the case may be diverted or misled, where the evidence is not enough for convictions of the offender. The court process. If the preliminary investigation results in the finding that a crime has been committed and the suspect is probably guilty thereof, the public prosecutor will file the corresponding information in the proper court, thus activating the judicial process. So, the case shall then be set for arraignment, which is the first stage of a criminal action. It consists of the reading of the information of criminal complaint in court to the accused of in open court. The accused is then asked how then hand he pleads. The accused may plead guilty or not guilty to the offense charged. If he refuses for him, if the accused pleads guilty, the court shall sentence him to the corresponding penalty. It is satisfied of the voluntariness of the plea and otherwise of the guilt of the accused. If the accused pleads not guilty, the case is set for pre-trial and or trial. The pre-trial such I shall consider the following matters. plea bargaining, stipulation of facts, marking for identification of evidence of a parties, waiver of objection as will promote as admissibility evidence, and such others matter will promote fair and expeditious trial. No agreement or admission during the pre-trial shall be used evidence against the accused unless reduced in writing signed by him and his counsel. After the pre-trial stage, trial follows. The prosecution commences the presentation of evidence followed by the accused. Prosecution may present rebuttal evidence. The parties may also present written arguments or memoranda, after which the case is deemed submitted for decisions. The law secures to every accused the following rights during trial: to be presumed innocent until the contrary is proved beyond reasonable doubt, to be informed of the nature and cause of the accusation against him, to be present and defend in person and by counsel at every stage of the proceeding, from the arraignment to the promulgation of judgment. The accused may, however, waive in his presence at the trial pursuant to the stipulation set in his bail bond, unless his presence especially ordered by the court for purposes identifications. The absence of the accused without any justifiable cause at the trial or particular date of which he had notice shall be considered, and waiver of his right to be present during the trial. When an accused under custody had been notified of date trial escape, he shall deem to have waived his right to be present on said date and on subsequent trial dates until custody is regained. Upon motions, the accused may allowed to defend himself in person when it sufficiently appears to the court without the assistance of counsels to testify as a witness in his own behalf, but subject to cross-examination on matters covered by direct examination. So, the court process is the pre-trial shall consider the following matter, like plea bargaining, stipulation of facts, marking for identification and admissibility of evidence, and such other matters as will promote a fierce and expeditious trial. No agreement or admission during the pre-trial shall be used evidence against the accused unless reduced in writing and signed by him and his counsel. After the pre-trial stage, trial follows. The prosecution commences the presentation of evidence, followed by the accused. Prosecution may present rebuttal evidence. The parties may also present written argument and memoranda, after written argument memoranda which the case is deemed submitted for decisions.